Hello, everyone, and welcome to another COVID-19 law and policy briefing produced by Public Health Law Watch, which is a George Consortium initiative at the Northeastern University School of Law. I want to thank our co-sponsors, who are the Center for Public Health Law Research at Temple University, the Network for Public Health Law, and Change Lab Solutions. As always, we are here to provide expert legal analysis during the COVID-19 pandemic and hopefully to answer some of your questions on important topics that are still really at the forefront of our minds and our discussions. And also for more information on the COVID legal response, I want to remind everyone that you can check out our two reports, which are available at www.covid19policyplaybook.org at the Public Health Law Watch website. The reports are a really wide-ranging assessment of the COVID response and all the legal issues that have come up by over 50 different legal experts. So we encourage you to look at that. I am Lance Gable. I am an associate professor at Wayne State University Law School. And joining me today are my great colleagues and friends, Wendy Parmet, who's the Matthews University Distinguished Professor of Law and Professor of Public Policy and Urban Affairs at Northeastern University School of Law, and Scott Burris, who is a professor of law and public health and the director of the Center for Public Health Law Research at Temple University Beasley School of Law. You can please, if you want to comment on our briefing, please use the hashtag COVID Law Briefing for questions and comments in response to the briefing. So today we're talking about the shadow docket, and we're talking about some of the really important and consequential developments that have been going on in public health law and interpreting public health law over the past year in response to the pandemic. We've seen a lot of legal challenges over the past year to state and local government orders that were issued to respond to COVID-19. And while the vast majority of these orders were resolved in favor of the governments that issued them, most of them were upheld. There have been some notable exceptions, and these exceptions go right to the heart of how government authority to respond to pandemics is going to be evaluated by the courts going forward. And so in today's briefing, we're going to discuss these developments and the impact of the Supreme Court's shadow docket decisions on public health powers and what these decisions might mean for the future of public health interventions in pandemics and more generally. So my first question is, I'm going to direct it to Wendy. The Supreme Court has weighed in on a number of these challenges to state and local pandemic orders. Despite initially supporting a position of deference to state and local governments on these pandemic orders, the court has, in more recent cases, overturned some orders. And I just wanted to ask how these decisions compare with past precedent for these types of cases.
Well, thank you so much, Lance. So the cases we're talking about, to be clear, are all from the shadow docket, and I know we'll talk more about that. And they're really all free exercise challenges to state orders. The most recent cases, and they were all decided after Justice Amy Coney Barrett joined the court, and that really marked a shift in the court's approach. And they diverge, I think, pretty dramatically from the court's own two earlier cases on COVID that were decided before Justice Barrett came to the court, as well as the approach adopted by the majority of lower courts in the early years of the pandemic. I think several points stand out as we think about sort of what's remarkable about these cases and how do they diverge from precedent. First is the diminution, if not outright, dismissal of Jacobson versus Massachusetts. The 1905 case has widely been thought of as the foundational public health law case, and it was relied on very broadly in the early days of the pandemic, including in an opinion by Chief Justice Roberts, concurring in the court's first COVID case, which rejected a free exercise challenge to a restriction on worship. That case, anyone who's interested, is South Bay United Pentecostal Church versus Newsom. In the more recent cases, after Justice Barrett joined the court, the majority has not cited or relied on Jacobson at all. Jacobson's just absent. Although in an earlier dissenting opinion in one of those two first cases, Justice Alito stated that Jacobson was only a quote unquote modest decision and that it had no relevance to First Amendment cases. He's certainly right Jacobson was not a First Amendment case. It is not dispositive. Its application raises a lot of questions. But I think most of us thought, most people in public health law and most lower courts thought it still was an important precedent and had some messages to offer. The current Supreme Court seems not interested in whatever it has to say, which leads me to my second point. There's no deference at all to state or officials in these cases. In the later cases, the court doesn't even give deference to the threshold question of whether or not strict scrutiny is applicable, right? We never expect deference in strict scrutiny, but there's an initial question as to whether or not the state laws discriminate against religion, or are they general laws of neutral laws of general applicability. And there's no deference given to that question. Nor does the court give any deference to factual findings of lower courts. And in effect, and sort of as a bit of a cheap shorthand, I want to say, it's almost strict scrutiny to strict scrutiny. If somebody comes in and challenges a COVID law as violating, as substantially burdening their practice of religion, strict scrutiny all the way. The last thing I'll say is that not only is there no deference, but there's no engagement by the justices with public health evidence. It's not that they're not deferring to what the state says. They're not looking to evidence. They don't seem interested in the evidence. They seem, I think, to rely on their own intuition as to when the states are treating religious exercise as comparable or not comparable to secular activities.
Thanks, Wendy. I want to let Scott jump in here for a second, and I guess the follow-up is obviously the cases which have been most consequential and where the court has really taken this new approach have been cases that involve claims of violation of religious free exercise rights. The plaintiffs have been religious institutions challenging the pandemic orders, and I wanted to ask you how that factors into how you think that factors into where the court is going with these cases.
I think that's the crucial explanatory factor, actually. I don't, in a certain way, think these are public health cases. I think they were cases that provided a new majority on the Supreme Court that was pretty activist on expanding the scope of the religion clauses to expand that scope. There are 4 justices on the court now, Kagan, Sotomayor, Breyer, and I would add the Chief Justice, who would have treated these as public health cases by and large, and who therefore talked more about Jacobson and talked more about evidence. I think there's an interesting story in these cases about Justice Roberts' disenchantment with the performance of health agencies in making distinctions and justifying them. But I think he takes that enterprise seriously. In fact, he takes it so seriously, his irritation in some ways kind of drove some of his writing. But for the new majority, I think it's all summed up by, there's a number of just smoking gun kind of passages where they just give vent to their feeling that religion has been mistreated for too long by secularists, and it's about time things changed, and we're drawing the line right here. And in Tandon v. Newsom, the way they state the case as government regulations are not neutral and generally applicable, and therefore trigger strict scrutiny under the Free Exercise Clause whenever they treat any comparable secular activity more favorably than religious exercise. They are taking a really simple view of the initial decision that Wendy points to, should there be strict scrutiny? And if they can kind of find another activity that's secular, that's being treated better, that's all it takes. And find distinctions about like what goes on in that space and how long people stay in that space and all sorts of questions that the dissenters took more seriously. This group just shoves aside, jumps to strict scrutiny, and gives us a new world of public health. And really importantly, then, they are taking the Free Exercise Clause and potentially the religion clauses generally here, to the same place that commercial speech has brought us on the speech clause. Right? So a situation in which things that we used to regard as public health questions that should be addressed by some kind of deferential, rational basis scrutiny are now First Amendment civil rights questions. And the burden is on the agency not only to provide strong evidence that the particular thing they want to do is effective and will work and is necessary, but through the guise of less restrictive means to essentially falsify the efficacy of every other conceivable step you could take. And that's just in practice, not a burden that health agencies can take. And that's where I think these cases have future importance for public health.
Totally agree with everything that Scott said. But I want to emphasize that in the court's first case on this path, Roman Catholic Diocese versus Brooklyn, which was decided on November 25th, the court was reviewing a very draconian closure of religious institutions, churches and synagogues in New York. And there was some, I would say, not well stated statements by Governor Cuomo. The court could have, would have, right, based it and found that the order was motivated by animus. Or they could have focused on where the state singles out worship. But when you get to fast forward to the most recent case, Tandem, this is a limitation on in-home gatherings. And the plaintiffs say, well, we want to have in-home prayer service. But the plaintiffs get to decide, right, that the law is burdening their religion. It's not a law about religion. It's a law about gatherings. So theoretically, if you close bowling alleys, the plaintiffs could say, but for me, bowling is religious. Now, I don't think the court means to go there. But I do think we need to recognize that the potential scope of this is quite extraordinary. And certainly many people are saying what the court is basically doing is giving a, opt-out, right? A most favored nation status. And so that has much broader ramifications, I think, for public health, because almost any public health law can, in fact, burden somebody's religion. And that's where the danger lies.
The idea that there is a broader agenda here could be, supported by the fact that in Cuomo, the orders were no longer in effect. And furthermore, interestingly enough, there were orders among all the orders we saw that were actually kind of targeted in the sense that New York was facing big outbreaks demonstrably tied to religious gatherings. The fact that this was a shadow docket case that's supposed to be emergency relief in situations where it cannot wait. And of course, non-precedential because of, some people say non-precedential because of the timing and the pace and the lack of full briefing and so on. Yet the court went ahead and issued an order just in case Cuomo decided to change his mind again. So you have that real pressure, that sense that, we're really going to draw a line here.
Let me jump in for a second and go back to the point about the shadow docket, because I think this is a relevant part of the story, which is that these cases were decided on a different procedural positioning than we typically see with Supreme Court decisions that change longstanding precedent. And so I guess I'd like both of you to talk about that. What are the implications of making these precedential shifts through this mechanism, and what does that mean in terms of how precedential these decisions are going forward? I'll go to Wendy first.
Thanks. Well, the shadow docket is a term that Professor William Boyd gave for the orders and decisions that the court renders on cases that are not heard on the merit. It's emergency docket. And the key point here is, first, the cases lack oral argument. They lack full briefing, all the parties, all the amicus briefs, the whole rigmarole that we're used to with Supreme Court's merit cases are gone. And the opinions are issued very quickly. Most often, these are just denials of requests for stays, right? Or stays without opinions, whatever, big deal to the parties, but not the big deal to the rest of the world, and not precedent. These cases feel really different. They're issued in an emergency basis, pretty much always late at night before a holiday or a weekend. But The court is treating them like they're a big deal, right? First of all, we're getting opinions and concurring opinions and dissenting opinions, right? This is like a big deal. Secondly, the court is treating it like precedent, right? In fact, in the most recent case, Tandem, which Scott mentioned, the court admonishes the lower courts for not following its decisions and its reasoning from the shadow docket. And the court majority cites concurring opinions from the shadow docket. So the court is treating it like it's precedent. I think this is very dangerous. One of the problems with cases from the shadow docket is the rush nature. And you do get the sense of anger and venting, and they're doing this quickly, but you don't get the sense that they have had the time that a court should do, that is really the Supreme Court's job, to, take a deep breath, deliberate, think about what this means in other contexts. How will this be used in cases about, childhood vaccines? How will this be used in cases about restaurant regulation, food safety, right? Quarantine. The cases are being used as precedent, but the court has not necessarily had the time or the inclination to really think this through with the deliberative process that I think we would hope for something that is potentially as momentous as these cases.
I'm not sure how much these tell us about pandemic control, actually. We're going to be on sort of recovering or sifting the ashes of COVID for a long time. But, in my sort of legal realist account of 200 years of public health law, I think that no matter what doctrine and level of deference courts purportedly applied, their judgment of the actual necessity of the measure always came into play. And when you see a court overturning a measure, whether it's in Juho v. Williamson and the plague restrictions in California, or it's what I think of as a classic public health law case, even though it's an ADA case or a Rehab Act case, Arline v. School Board, or these cases, if the judge is just not convinced that the health department has it right, or should put another way, they feel pretty strongly they got it wrong, by whatever standard, they are going to step in if there's some significant rights being restricted. What we have here is a collision of two really, important things about the COVID epidemic and about the court. On the one hand is I think, overall shambolic response of public health to the COVID epidemic. And I shouldn't just say public health, the politicians, to all the lines that were drawn, to the crazy forms that were made with 16 different levels and different colors and all this stuff, completely nuts in terms of, ability to get compliance and do implementation in a divided country. So that's coming this way. And this way is coming a new Supreme Court, or a changed Supreme Court, where people are really head up to start expanding the religion clauses. Those two things have collided and given us these decisions. It's not the whole court. It's four for sure. I mean, in an interesting sense, if we look at like a case like South Bay closely, the religion didn't win completely. They got some and they lost some. And Barrett and Roberts were both swings. So, in terms of, and again, we have a solid four justices who really do kind of accept Jacobson as a guide to deferential, prudential judging in pandemic emergency situations. So I think we're gonna have to wait and see how this plays out beyond the religion clauses. But on the other hand, to move to another amendment, the five diehards here on these cases have left a loaded gun on the public health law table that anybody can pick up in future cases and see if it can shoot a bullet. And so I'm scared.
But part of the mystery of the shadow docket, and I agree with everything Scott said, is I don't know what to do with the somewhat mixed decision in South Bay 2, because South Bay 3 vacated the orders as they applied to the singing and chanting. So, have Roberts and Barrett now gone along and said that was, everything should be enjoined? Again, silence, right? We don't know. There's so much we don't know. But I agree that the biggest question here is, well, first, I totally agree. Bad facts make bad law, and there were bad facts, and there was judges itching to change the law. But this opens up the litigate. It's not just what will the Supreme Court do in a childhood vaccine case, when somebody challenges Connecticut's law rolling back religious exemptions, but it's also I think we should not underestimate the extent to which these decisions, and depending in part on what happens in Fulton, and I guess we'll get to that as that, invigorates efforts to challenge these laws on free exercise, right? So, if you're in a public health department, you're a governor, and even if you got good facts and you got science on your side, you're going to have your general counsel saying, if there's not a religious exemption, oops, people, right? That, I think, the way these cases will be interpreted and the way officials will now worry about exercising their powers in ways, I think, is significant.
Yeah, and just to add to that, I think that one after the Brooklyn Diocese case, the analysis looking at especially Gorsuch's concurrence and really focusing on the umbrage he voiced about religious institutions not being deemed essential. One takeaway from that could have been to say, well, okay, if you're issuing your orders, don't categorize different institutions as essential and non-essential. But in the Newsom case, it seemed like that really wasn't really that important to the analysis. They came to the same conclusion even without that particular perceived slight to religious institutions.
Well, and they also basically said in Tandem versus Newsom that in discussing comparability, which is that critical gatekeeping question, the benefits of the activities are not relevant, right? All that matters is the comparability of the risk. And so, and this is an example I've been giving, if hospitals are open, churches need to be open, right? Because hospitals are risky places in pandemics. They're also really essential in pandemics, but you can't look at that, the court says. Now, again, do they really mean that? If everything was locked down but the hospital and the police station, do they mean that? I think that is part of the problem of the shadow docket, is that they're saying things and offering tests without necessarily having thought through the implications. But, some lawyer somewhere is going to pick up that statement and run in a way that we'd say, oh no, that can't possibly be the case. It can't possibly be. If you shut down absolutely everything except police and hospitals, you can't shut down crowded, choruses chanting in the church. But if I just look at the opinion, it seems like you can. And that's the problem, I think.
Yeah, so I actually want to make sure we do also, Fulton has come up a couple of times, the Fulton versus City of Philadelphia case, which is pending in front of the Supreme Court right now. And this is not a shadow docket case, but it's a case that can have some really important implications for the future of how free exercise challenges to generally applicable laws are evaluated by the court. And so I wanted to get both of you to weigh in on your thoughts about that pending case and what it could mean for public health law going forward.
So Fulton was argued back in, I think it was November, and it is a case that is where a Catholic agency is challenging a City of Philadelphia law that refuses to contract with and place children in through foster care agencies that won't work with same-sex couples. One of the questions the court granted cert on, not the only one, is whether or not it should overrule the Supreme Court's earlier sort of landmark decision in Employment Division versus Smith, right? which is the case that says strict scrutiny is not applicable when there are neutral laws of general applicability in free exercise cases. When Fulton was argued, I think the general assessment was the court was not going to go there, right? And there are a lot of ways the court could decide this case on a narrower basis. They could decide for Philadelphia, but I wouldn't bet very much on that given what we've been seeing. But they could decide it on narrow grounds. For example, they could do what they did in Masterpiece Cake and find animus towards religious, right? And make it a very fact specific. They could adopt and announce the comparability analysis that we saw in Tandem, right? So they could take Tandem out of the shadow docket and bring it to center stage. That would not overrule Smith, but that would sure squeeze Smith. Or they could go all the way and overrule Smith, which would be a very dramatic move.
Scott, do you have any additional thoughts about that one?
Well, you know, I'm rewriting a chapter in my public health law textbook on the First Amendment, and I'm really keen to get it done. But I feel like, well, I guess I had better wait because the future is going to be interesting.
Yeah, and so on that point, I guess we should probably wrap things up in a minute. But I guess, do either of you have any final thoughts, reflections about where we're likely to be going? What does the future of public health law look like with these precedents in place, and what should we be thinking about now to make sure that there is some capacity to try to protect population health in the light of these types of potential challenges in the future?
I'll give Wendy the last word and say, you know, I think the easiest answer is that the First Amendment has now become unitary in terms of public health. Anything that has to do with religion is going to be about as tough to do as anything that has to do with speech. And it's going to be, and essentially what the court has maneuvered us into is a world in which the options for any kind of informational or behavioral nudge, let alone, you know, emergency responses to sudden threats, the room for that is going to be limited if it touches anything in the First Amendment, and because I think, you know, as I said before, there is just no way that public health measures will generally be able to satisfy strict scrutiny.
My slight caveat to that, or amendment to that, Scott, is that I think what Tandem also teaches us is that any law could potentially touch religion, right? So, you know, First Amendment, obviously broad, a lot of discussion about, you know, expressive speech, but in this general, we know the core of what's within the speech clause. You know, if anything, you know, people can have religious objections to any law. And so I share Scott's concern about where this is going and how difficult it will be to enact and impose almost any measures designed to protect the public's health, both day in and day out, and in another emergency. I do think that the court, I think they're feeling newly emboldened. I do think that they work motivated, as Scott said, by some very bad facts and the crazy of, if I can call that, of the past year. I suspect that they really don't want to, you know, get rid of laws that say you have to stop at a red light if you say, well, God told me to drive through the intersection. So I think we're going to have to see eventually some moving back and some recalibration. Maybe Fulton will take us there, maybe not, but I think it's a rocky road ahead. And maybe one without stop signs.
Okay, well, I want to thank both of you for this fascinating discussion, and I want to thank everyone for listening today. We are going to be continuing to do these COVID law and policy briefings every Tuesday and Thursday. We're back here for a number of episodes this summer, so keep tuning in at Public Health Law Watch Twitter account. And also, the recordings are available on the Public Health Law Watch website. The shows are also archived by the Week in Health Law podcast, which is www.twihl.com, TWIHL. And I also want to thank our producers for the COVID Law and Policy briefings, Faith Kallick and Bethany Saxon. Thank you. We'll see you next time. Please stay safe. Keep washing your hands, wear your masks where they're still needed, and please get vaccinated. Thanks, everybody.